So we are continuing with the main keynote address. My name is Christian Fuchs, and I'm chairing the session, and I want to introduce our speaker to you. Let me also say that we have created a Twitter hashtag for those who like to tweet about the conference and also about the main keynote address. So it's hashtag FOIUP, which stands for Freedom of Information Under Pressure. Our main keynote speaker is Gill Phillips, and I would like to introduce her to you. She's a media law specialist who is the director of Editorial Legal Services for the Guardian News and Media Limited, that publishes the Guardian and Observer newspapers and also the Guardian website. She has previous experience working as a lawyer for the BBC, for news group newspapers and the Times. She joined the Guardian as the director of the Editorial Legal Services in 2009 and has ever since advised the Guardian in legal questions concerning hot political issues such as the phone hacking scandal in the UK and the Levinson inquiry that followed, WikiLeaks, and then also Edward Snowden's revelations about the NSA surveillance and PRISM surveillance system. And Mrs. Phillips will talk today about Edward Snowden, more questions than answers, question mark. She will first give a talk, and then we have reserved some time for questions. So you're also welcome to ask some questions. All right, so I would like to ask Ms. Phillips to first give a presentation.
Grüß Gott. That's it, I'm afraid, for my German. I'm very pleased to be here as a representative of The Guardian and to have the opportunity to give a talk to you all at this conference, this very important conference. As you know, The Guardian and its editor, Alan Rusbridger, have long been advocates of an open, transparent digital model for journalism, acknowledging and embracing the enabling power of the internet to spread news. As we near the 25th anniversary of the British creation of the World Wide Web, it's important that the UK leads the long-term debate about securing an open and secure internet in word and deed, so as to ensure that individuals and businesses can have faith, confidence, and trust in the online world. But only yesterday, I read in a risk list published by the Committee to Protect Journalists that top of this list was not a country, but the cyberspace. One of the key reasons given for this by the CPJ was the threat posed by mass surveillance as revealed by Edward Snowden. What we have seen and read in the last 6 months has clearly undermined our trust in the internet. The United States National Security Agency, the NSA, and its British partner, the Government Communications Headquarters, or GCHQ as we call it, in conjunction both wittingly and unwittingly with the internet and telecommunications giants, have used their technical skills to, quotes, master the internet, close unquotes. And you'll all remember that that's one of the programs that was revealed by Edward Snowden. The result has been a world that is spied on. The spy agencies have hijacked the internet. In June last year, Edward Snowden gave us a wake-up call. Since the Snowden revelations were published, presidents, parliaments, congresses, and courts have all been forced to react. Over weeks and months, it has become clear that the story is not about one man leaking classified information, but rather it is about really big and important civil society issues: privacy, civil liberties, national security. But it's also about the future of the internet itself, the digital economy, the nature of democratic oversight, the conduct of foreign relations, and much more. Now, as some of you may know, I'm a practicing lawyer and not a journalist or an editor or an academic. So it's from that perspective that I'm going to talk today. I will try not to be too legalistic, dull, or long. Regrettably, those three go hand in hand where lawyers are concerned. With that brief introduction, I'm going to start by showing a short film that endeavours to pull together all the things that have happened around the Edward Snowden story, just to put some of why we're having, in a way, this conference and these discussions in context.
For those who haven't got earphones, they are available on the backside, and the video is only in English. So if you would like to have some translation, you can get the earphones.
The NSA specifically targets the communications of everyone. It ingests them by default.
The United States is not spying on ordinary people who don't threaten our national security.
What Snowden is trying to draw attention to is the degree to which we are on a road to total surveillance.
The suggestion that somehow what we do is somehow compromising freedom and democracy, of course we believe the opposite to be the case.
This is something that's not our place to decide. The public needs to decide whether these programs and policies are right or wrong.
It's entirely appropriate for a program to exist to look at foreign data.
I announce today my formal acceptance of all offers of support or asylum I have been extended and all others that may be offered in the future.
Tivemos 6 agentes diferentes que eles estavam entrando e saindo, falando comigo, me fizeram perguntas sobre minha vida inteira, sobre tudo, levaram meu computador, videogame, celular, meus memory cards que estavam, tudo.
We were faced effectively with an ultimatum from the British government that if we didn't hand back the material or destroy it, they would move to law. Once it was obvious that they would be going to law, I would rather destroy the copy than hand it back to them or allow the courts to freeze our reporting. Well, I don't think that we had Snowden's consent to hand the material back, and I didn't want to help the UK authorities know what he had given us.
I think the plain fact is that what has happened has damaged national security, and in many ways the Guardian themselves admitted that when they agreed, when asked politely by my National Security Advisor and Cabinet Secretary to destroy the files they had, they went ahead and destroyed those files.
President Obama and Chancellor Merkel spoke by telephone, but the President assured the Chancellor that the United States is not monitoring and will not monitor the communications of the Chancellor.
The work we do is addressing directly threats to this country, to our way of life, to this country and to people who live here.
It violates every single decent and legal instruments that I can think of.
The Australian government uses all the resources at its disposal, including information, to help our friends and our allies.
I love this country. Do you love this country?
How do you answer that question?
We live in a democracy, and most of the people working on this story are British people who have families in this country, who love this country. I'm slightly surprised to be asked the question, but yes, we are patriots, and one of the things we are patriotic about is the nature of the democracy and the nature of a free press and the fact that one can in this country discuss and report these things.
I don't want to live in a world where everything that I say, everything I do, everyone I talk to, every expression of creativity or love or friendship is recorded.
In this directive, I have taken the unprecedented step of extending certain protections that we have for the American people to people overseas, which will limit the duration that we can hold personal information while also restricting the use of this information.
Mr. Snowden has nobly advanced our effort to save democracy. And in doing so, he has stood on the shoulders of others. Of Mr. Assange, Ms. Machen, Mr. Binney, Mr. Drake. The honor will be theirs, but the responsibility is ours. We must see to it that these sacrifices have not been in vain.
Thank you. So I hope that just gave a much more eloquent summary than I could ever do of what happened around the Snowden revelations. And although there are any number of things that I could talk to you about today in terms of freedom of information, press freedom, and the dangers, the threats that still exist to journalism, Snowden is what The Guardian has spent the last 6 months on, and it's appropriate that I use that as the basis for what I'm going to say to you. So following on from that, developments in modern technology have meant that the state's capacity to capture, store and use private communications is greater than ever before. And it's not just the state, it's commercial interests as well who can do this. This capacity, which developed exponentially during and after the Second World War, when the value and power of mass communication systems was recognised and exploited, but subsequently by other Western governments who recognised the counter-value of accessing and intercepting an adversary's communication systems and of breaking their codes. There have always been codes and code breakers, but it was the sheer scale of the Snowden revelations that made this so very different. This ability to capture, store and use private communications has had a profound impact on all key areas of information technology, and the ability of the intelligence and security services, as well as commercial entities, to obtain information on individuals, groups, organisations and corporations. Even in his relatively low capacity as a systems administrator for the US government contractor Booz Allen Hamilton at an NSA Signals Intelligence Operations Center in Hawaii, Edward Snowden had access to an extraordinary amount of electronic data about NSA surveillance activities, including documents which belonged to GCHQ, which were accessible to Snowden and his colleagues through the NSA systems. As we are all now aware, he is the source behind the biggest leak of classified intelligence data in history. In May 2013, Snowden took himself off to Hong Kong and shared his stash with a number of journalists, including Glenn Greenwald, then writing for The Guardian out of Rio, Laura Putras, a documentary filmmaker based in Berlin, Ewan McCaskill, one of The Guardian's most respected journalists, and Bart Gellhorn, a journalist with The Washington Post. And he provided them with a range of information running to thousands of files, showing that the US and the UK governments were using very broad powers to collect electronic data in a way that went beyond, way beyond, the targeting of suspects. But let us not forget, it was the NSA and GCHQ who lost this data in the first place. Subsequently, The Guardian, The Washington Post and Der Spiegel published a number of stories relating to the Edward Snowden material, some of which were featured in the film you've just seen, which revealed and attested to the extent of the American and British intelligence agencies' surveillance activities. People have often suspected those activities and the breadth of them, but what Snowden did was give us the evidence to show the extent. The Guardian later shared its Edward Snowden material with the New York Times and has retained joint control of such documents with the New York Times. Never before has anyone scooped up en masse so much about the intelligence organisations of two of the world's great democracies. Snowden did this so that the world would know the extent to which such states had been systematically abusing their power, going beyond the rule of law and invading the privacy of millions of private citizens. Some of the things we've learned from these revelations include, since 2006, the NSA has been systematically collecting records of every phone call and every email every American makes, as well as cell phone location details. In doing so, the NSA broke federal laws or exceeded its own authority thousands of times a year. That it reviews the contents of emails of foreign nationals overseas, including the German Chancellor and the Israeli Prime Minister. That the NSA has hacked into the communications link that run under the oceans, allowing it to spy on hundreds of millions of email user accounts. That GCHQ has been a compliant and willing accomplice in such activities. And most recently, it was revealed that GCHQ, with assistance from the NSA, through a program named Optic Nerve, between 2006 and 2010, has been collecting bulk still images from Yahoo webcam chats. These subsequent revelations have raised a number of wide-ranging questions. Let me pose just 6. First, there are questions around the transparency and public accountability of our intelligence agencies. Where are the proper boundaries between the state, the media, business, and individuals in the internet age? Secondly, there are questions about the adequacy of the oversight arrangements in a democratic society and the necessity for and proportionality of intrusions. Some argue, for example, that the case has been overstated, that much of the data collection is only metadata as opposed to content, so we shouldn't really be over-worried about what is collected. In fact, it's not really private data at all, and in any event, if you haven't done anything wrong, you've got nothing to fear, you've got nothing to hide. Others say that this is an entirely specious argument, which effectively would constitute a blanket authorization for any degree of totalitarian intrusion. Access to metadata can in fact reveal everything you have read, viewed, or downloaded, who you contacted, where you were at any given time. The response to the "you've got nothing to fear, nothing to hide" argument should be, in that case, you don't need to keep and search all our private communications data at all. In fact, what you are doing is warping the traditional balance of trust between the citizen and the state. Thirdly, there are questions over the moral authority of individuals like Chelsea Manning, Julian Assange, and Edward Snowden. Are Manning, Assange, and Snowden brave and heroic whistleblowers who have exposed the government's secret and legally dubious surveillance activities, or are they misguided? Are they criminals? Are they traitors? Fourthly, there are questions over whether the likes of Laura Poitras, Glenn Greenwald, and The Guardian should be given protection as journalists for revealing these materials. Is what they have done in the public interest, or should they too be prosecuted in order to curtail such disclosures? Some argue that the publication of highly classified material by journalists who have no expertise in handling this sort of material can never be justified. Is it possible to make distinctions between legitimate and illegitimate disclosures? If so, who should make such distinctions? In their recent judgment in the David Miranda Judicial Review, the UK court makes clear they do not think journalists should be doing anything connected with national security. Contrast that with the NSA's own lawyer, who said that it was for governments to keep secrets and the press to publish in the public interest if governments fail in those endeavours. Fifthly, there are questions around censorship and prior restraint, about what freedom of expression means in a democracy, about protecting sources. Finally, there are big questions about the commercial gathering and use of private data for targeted advertising and marketing, and again where the balance lies when balanced against an individual's right to respect for their private life and correspondence. Questions such as these, and there are many others, feed into many of the issues that are going to be discussed at this conference. Important issues about electronic surveillance practices, journalistic freedom, and how these fit into a democracy. Issues about how to balance our need for security with an individual's right to privacy. Going back briefly to the English High Court's judgment on the legality of the detention of David Miranda at Heathrow, the court worryingly, in my view, downplays the role that journalists have to play in a democratic society. While Lord Justice Laws accepted that the detention of David Miranda was an indirect interference with journalistic rights, he found that interference was justified. While he acknowledged that the protection of journalistic expression is an important subclass of the law's more general care for free speech, he went on to disagree with some of the leading judicial pronouncements on free speech protections, suggesting free speech was not in fact an ally of democratic government, and that suggestions to that effect were, in his view, false. He debunked 3 propositions that many might think were at the heart of a democratic society, namely that journalists have a role in a democratic state to scrutinise actions by government, that the function of the free press is inhibited by an insistence that anything in the security field which the journalist seeks to publish must be stifled because it may be part of the jigsaw from which a knowing terrorist may draw harmful inferences. And thirdly, that there is a balance to be struck in the security field between the responsibility of government and the responsibility of journalists. Lord Justice Laws said, taken at their height, these propositions would confer on the journalist's profession a constitutional status which it does not possess. The court, through this judgment, has in effect allowed the state to freely scoop up electronic communications in the form of personal emails, texts, metadata, biographical data. That cannot be right in a democratic society. Despite the judgment paying lip service to recognition that a modern democratic society requires a free media, it effectively leaves no room for investigative journalism where national security is concerned. While much of the focus of the debate about the Snowden revelations has been a binary debate between the competing public interests of privacy and security, the Snowden files actually illuminate many other public interest considerations that we should weigh in the round when discussing their impact, considerations that go to the fundamental issue of our liberty. Some of those other considerations include the fact that the NSA and GCHQ's activities have risked the integrity of the web itself through using programs that have weakened encryption protocols, that the privacy and integrity of businesses and consumers have been compromised through the insertion of secret backdoors into online software, that the activities of the NSA and GCHQ have undermined legal privilege in commercial and criminal cases and put at risk the confidentiality of journalistic sources and materials, that their activities have threatened the future of the internet and undermined the very foundations of the future digital economy. One Washington-based foundation predicted a potential economic loss to the US cloud computing industry of as much as $35 billion by 2016. That they have made a mockery of the concept of political oversight regimes. In the United Kingdom, for example, it is clear that parliamentary sovereignty has been circumvented. The UK Parliament has previously rejected government calls for the capability to collect bulk data communications of British citizens, yet that is exactly what GCHQ was doing. In weighing up these competing public interests, one has to acknowledge that there can be good reasons for some secrets to stay secret, especially in foreign relations or during wartime. The first duty of the state, no one would dispute, is to protect its citizens. National security and keeping citizens safe is therefore very important. No one disputes that catching, convicting, and where appropriate, imprisoning those who would do states and their citizens harm is good, but it is easy for states to use that justification to increase state power. What you have to remember is not to be blind to recognise that every state employs secret surveillance agencies and a variety of methods to protect what it regards as its national interests. You would be foolish to think that this doesn't happen and that we could ever live in a society where it doesn't happen. That's what George Orwell recognised when he wrote 1984. You will recall that technology played a significant role in the detection of thought crime in 1984 with the use of telescreens, which could monitor the citizens of Oceania, watched by the thought police. And yesterday's revelations about optic nerve were very reminiscent of some of those capabilities of the telescreens. Every moment, every reflex, every facial expression and reaction is measured by the telescreen system in 1984. It's monitored by the Ministry of Love. Let me just read out a very short extract from Chapter 1 of 1984. Any sound that Winston made above the level of a very low whisper would be picked up by it. Moreover, as long as he remained within the field of vision, which the metal plaque commanded, he could be seen as well as heard. There was, of course, no way of knowing whether you were being watched at any given moment. How often or on what system the thought police plugged in on any available wire was guesswork. It was even conceivable that they watched everybody all the time. But at any rate, they could plug in your wire whenever they wanted to. You had to live, did live, from habit that became instinct, in the assumption that every sound you made was overheard and, except in darkness, every movement scrutinised. And echoing those words almost 30 years later, Edward Snowden told Glenn Greenwald he didn't want to live in a world, quotes, where everything that I say, everything that I do, everyone I talk to, every expression of love or friendship is recorded. So it's very interesting 30 years on to hear the echo in those words. What's also worthy of noting in the context of this discussion is the contrast in the debate in the UK, Europe, and the United States. In both the United States and Europe, there has been a deep and fulsome debate about the balances and public interest issues that arise from the Snowden revelations. In the US, there are going to be some pretty sweeping reforms of the NSA. Contrast the findings in the US with the unchallenged assertions, some of which you saw on the short film from the British intelligence services about the efficacy of these intelligence programs. In the United States, the media, the general public, policymakers, and the President address what is and will remain the most pervasive challenge of our lifetimes, the limits of state power over our digital lives. That debate has been open, transparent, and honest. Most recently on the 23rd of January, with devastating findings of agency overreach by the US President's own Privacy Oversight Board. This approach has led to wide-ranging presidential reviews, a range of bipartisan acts in Congress, cases brought before the courts challenging the legitimacy of the practices of the NSA, and a series of reforms announced by the White House. But, as Alan Rusbridger wrote in a recent article in The Spectator, the discussion in Britain, both politically and in the press, has been much more muted. I have heard it said that one reason for the muted nature of the debate in the UK may be that we have not, in recent memory at least, been occupied by a foreign power, so we have no idea what that means or what the implications of it can be. The British Prime Minister David Cameron, speaking at a press conference in Brussels in October last year, shortly after the revelations, that the US had tapped the phones of friendly European leaders, said as Prime Minister he could not afford to have a la-di-da, airy-fairy view of the work of the intelligence services, and had lost count of the number of plots that MI5, MI6 and GCHQ had foiled. We continue to play down the seriousness of these revelations. So what are some of the solutions to the wake-up call that Edward Snowden has given us? Let me end with just a few suggestions for the UK. One, we should allow intercept evidence to be used in courts. The reason that agents hate it and the intelligence agencies hate it is that they fear it will involve revealing their methods in court. But actually, courts are a pretty good way of revealing those methods subject to proper scrutiny, and in doing so, providing a reasonable level of transparency. We need to reform and tighten the Regulation of Investigatory Powers Act, which is the main act in the UK that is used by the intelligence services to collect, store, and access data. That act came into effect in 2000, and it's clear when it was passed, Parliament had no idea about the growth in the capacity and capability for collecting, holding, and processing data that exists today. RIPA contains no meaningful assessment of proportionality when compared to outcome achieved. The mass interception of data is a disproportionate interference with privacy rights under Article 8. There should be some sort of judicial rather than ministerial oversight so as to ensure some sort of proper independent scrutiny. Currently, there is no meaningful independent restraint on the exercise of executive discretion in respect of internal communications. Thirdly, we need to introduce a much more thoughtful and transparent system of parliamentary oversight and scrutiny. The Intelligence and Security Committee of Parliament and the Investigatory Powers Tribunal are not good enough. Some changes have been made to the Intelligence and Security Committee as a result of a recent act, which do strengthen its independence and resources, but these do not go anywhere near far enough. Both the ISC and the Investigatory Powers Tribunal need to be reformed so that they have access and sufficient information themselves to be able to ask the relevant questions and to properly scrutinise the operations of the security and intelligence agencies. They also need to have the power to request documents so as to make sure they can properly hold the agencies to account. There's no transparency around the Investigatory Powers Tribunal. It operates under an almost blanket rule of secrecy, and there's no appeal from it. RIPA removes the jurisdiction of the High Court to any challenges. Fourthly, we need to make sure there are proper legal processes in place to ensure that individual rights are properly protected. And finally, we need to introduce proper safeguards to protect legal and journalistic material so that it is not swept up in these mass surveillance activities. And finally, please don't shoot the messenger. If Edward Snowden hadn't done what he did, and Glenn Greenwald and The Guardian and Der Spiegel and the New York Times hadn't published what they so carefully did, we probably wouldn't be here today having this discussion because we wouldn't know any of it was happening. Thank you all very much.
So thank you very much for a very interesting keynote speak, Gillian. And we would like to collect some questions, maybe 3 questions that we can collect. Right, who wants to go first? Yeah, there's a question here.
Thank you. Thank you. Does it work? Yes. My name is Barbara Trionfi from the International Press Institute. There are a lot of discussions following the Snowden affair with regard to whistleblowers' rights, but I see less discussion of those still, to a certain degree, about journalists' liability for revealing information that they know is protected, a state secret. How do you see the law in the UK in this area, and do you see the need for reforms in this area, legal reform? Thank you.
All right, we can have 2 more questions. you want to answer to this one?
Yes. So, I mean, the fact is that journalists generally aren't seen as whistleblowers. Journalists are seen as the mouthpiece of the whistleblower. And journalists have some constitutional protections in different jurisdictions on that basis. And it seems to me on one level, whether you're whistleblowing about national security issues or about health or crime, shouldn't make any difference. There should be no particular distinctions. I mean, ultimately, people are going to judge you by whether there is a sufficient and legitimate public interest in what you're revealing. Because if it's too low level, people are going to say, well, why would you think that was worth somebody betraying the trust of X or Y? And I mean, in the UK, we have some protections around journalists' right to protect their sources. So that's one level of it. In terms of the personal liability of journalists, I mean, I think it's an incredibly wide-ranging question, and it's sort of where do you start? Because one issue is what's a journalist these days? You know, the old traditional definition of journalist as someone who worked for a news agency or a news organisation is probably no longer valid, because there are lots of people who would consider themselves to be journalists who blog as individuals or for a small group, for a very limited interest group. And so there are issues around that. And I think, you know, one solution to that is that you shouldn't be looking at whether someone is a journalist. You should be looking at what it is that they publish. So if you are publishing material that is in the public interest, that should allow you, whoever you are, to have the necessary protections. So if you get sort of beyond that as a definitional process or problem, then you've got to ask yourself, should journalists have special protections, I suppose, in particular situations, above and beyond the normal citizen? And you know, one of the things that's in the David Miranda judgment is this definition of journalism as being a subclass of an individual's right to free speech. And again, that's a very complicated sort of philosophical process to go into. But I mean, in the UK, there are very few specific public interest defences for journalists in criminal statutes, mainly because most of those criminal statutes were not designed with prosecuting journalists in mind. What we have got is we've got guidance from our Director of Public Prosecutions as to matters that should be considered when you come to prosecute the media for criminal offences, and that would include national security issues. And essentially, they look at the normal tests that they would apply when they prosecute anybody for anything. Are the elements of the offence made out? And more generally, is there a public interest in the prosecution? If you get through that phase, there is then a second set of questions, balancing questions, that you ask before deciding whether to prosecute a journalist. And actually, you know, to sort of focus in finally on answering the question, it seems to me that that's probably a very sensible way of dealing with matters, because it's so hard to be prescriptive in an act for a journalist in particular. Whereas if you have a system, a set of guidelines that is going to say, in any given case, we will apply a balancing consideration, and that's going to look at the seriousness of the revelation against the public interest in that revelation. And that really comes to a fore, particularly on national security issues. You know, that's going to be a high-end balancing matter. And you know, we have statutes, the Official Secrets Act, which talks about damage. You know, one of the things that The Guardian has been very careful, it believes, not to do is to have published anything that is damaging operationally or to individuals, as opposed to publishing material that might be considered to be embarrassing. And you know, people's views will differ about what's embarrassing and what's damaging depending which side of the fence you come from. But that, you know, that seems to me to be a reasonably proportionate place.
All right, are there more questions? Yes, there's one there in the back.
My name is Markus Euskirchen, Rosa-Luxemburg-Stiftung, Berlin. Question to you as a legal person. Do you discuss with your colleagues the possibility of a more offensive turn if it comes to propositions. For example, using the anomaly of open source free software code in contrast to privately owned and closed code as a basis for transparency on the level of the means of production of information and opinion. Second possibility would be the dispossession of the agencies that obviously have failed, that control the infrastructure, the networks and the net nodes, and transform them from privately owned institutions in public institutions.
Thanks so much. We'd like to collect maybe one more question if there is one. Yeah, there's one here.
William Horsley from the Centre for Freedom of the Media, University of Sheffield. What about the talk from the authorities in the UK about a possible criminal investigation of The Guardian itself? What's the state of play on that? And if it's not too large a question, is there not really an arms race seen to be underway among the major powers of the world in this area? And is it already out of control in terms of the capacity both defensive and offensive to spy on the internet?
All right, thank you. And I think I would like to add one question myself also, because I think what we can observe since 9/11, I mean, it's also kind. You can hear me? Can you hear me? Oh, all right. I think I'd like to add a question. What we can see since 9/11 is a change in the general public discourse. So there's the idea that more surveillance can be a technological fix to social problems like terrorism and organized crimes. And of course, ever since 2001, we've seen the massive intensification and extension of surveillance. And what do you see as the main changes in the legal frameworks that have taken place ever since?
Okay, starting with one of William's first question, which I can deal with quite shortly. There's been much misreporting around the police investigation. The police have said when they detained David Miranda that there would be an investigation into what he was carrying and the issues around that. There has not been, and as far as we are aware, there is not an investigation into The Guardian. Now, that's not to say that some people are not calling still for there to be one, and indeed for Guardian journalists or the editor to be prosecuted. But to date, as I think Cressida Dick said at the parliamentary committee immediately after Alan Rusbridger gave evidence, that the investigation is into the David Miranda issues, not into The Guardian or what The Guardian has been publishing. So in terms of the law, I mean, you know, the reality is that the law, if you have a statute-based law, it can be slow to catch up. That just the process of change of law can be too slow. And while having, on that basis, sort of fairly wide general definitions in law that allow courts to interpret them and move on, can be a good thing. The generality and vagueness of that can also be a problem, I think. So, you know, the fact is that I think on the oversight issues, RIPA and the 2001 Crime and Security Act, that are the main basis, those are clearly out of date and need revision as far as the powers that there are to collect this data. I mean, the other side of the coin is the issues around that we've sort of touched on in the first question around what can be done to journalists as a result of these things. And those people who've heard me speak before will have heard me say that, you know, when I started practicing as a media lawyer, although it wasn't really ever called a media lawyer in those days, there was very little crime that you were concerned with. You were concerned with civil law issues around defamation primarily, a little bit of copyright, and in the UK we have contempt court reporting issues. Privacy came in the sort of 90s as an issue for lawyers, for media lawyers, and then since 9/11 and those sort of issues, the ability of criminal acts to criminalise journalists and for journalists to go to prison for those acts has sort of risen up the agenda. And so as an in-house lawyer now, I do have to be far more aware of the potential for terrorism legislation to impact on journalism, whether it's low-level stuff around taking pictures of the police in the street, rising up to interviewing journalists, journalists interviewing terrorists, and then being asked by the state to hand over the notes of those interviews, or further to reveal who the terrorist was, where they were, how they found them, etc. So all those are issues that come around. And if you sort of think that on one level, what Snowden suggests is that all of that doesn't really matter because the state probably has all that information on some level and can just dive into the pool, put a few keywords in and come out with it, then that's very dangerous. And I'm not sure I entirely understood the first set of questions, but I mean that there are all sorts of things that have changed the way the game is played. From my perspective, and this really came out with WikiLeaks, if there are restrictions in the UK legally around what we can do, then you can do collaborations with newspapers in other jurisdictions. Now that might mean that you give away your exclusive or you share your exclusive as a newspaper, but you can thereby ensure that material gets published that 30 years ago might not have been published. So that's a good thing. On the other hand, how you secure all these methods and make sure that material is published responsibly, which is part of what a news organisation like mine is about. It is about responsible publishing at the end of the day, subject to all the other difficulties that there are around it. That can be tricky. So the Guardian uses all sorts of open-sourced material these days to contribute to and enlarge its journalism. So one of the things it did around reporting the riots and the Arab Spring was the Guardian had Twitter feeds from people on the ground who were seeing things and saying what they saw, and that's completely changed the way that journalism is. Once upon a time, journalism was an employed person who purported to have expertise in a particular area, telling their audience their view of what they saw. Nowadays, you have much more opportunity for 360-degree reporting of things. So the journalist's voice is just one voice in a much bigger story. And all of that throws up enormous complications, just practically, let alone legally. Legally, the reality is that nowadays we can be sued anywhere where you can download our material. So we can be sued in any country in the world. And do I know the laws of every country in the world? No, I barely know the UK's laws. So, keeping in tabs with all that, you have to do a risk assessment. You have to consult lawyers elsewhere when you need to. Sometimes you don't know that you need to until it's bitten you and then it's too late. So there are many practical issues that we're having to deal with and learn about in an ever-changing world. I mean, for me as a media lawyer, I'm constantly going, so once upon a time we just had a paper, then we had a website, then we had some sort of variation of the paper that was accessible via the website, then we've got a mobile app and an iPad app, and is it the same material that's on all of those things? And they go, well, no, not exactly, because we had to rewrite this for that. I mean, keeping tabs on all that is an enormous job these days.
All right, and we have to draw the session to a close. There will be a break now, but let's thank Ms. Phillips for a very interesting talk and a very good discussion. Thank you.
Thanks very much.